Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, they're holding up half the sky. Raise your hand if you're ready and willing. If you know it's time. Time for a girl on time. Time for a girl on time. Time for
No, William, that's right. My internet moose has been taught a lesson. I hope everybody's doing well today. I'm so glad to see you all. It is beautiful out. Barb, don't worry. We may get more gifts. We may not. We have a whole week to deal with that. Mistaken Reaper's here. Vicky's here. MB, my love. I hope that everybody is doing well today. Oh, Cole, how are you feeling? Thinking about you. We have so many friends. We're always sending out positive vibes to them. Today, I worked pretty hard. I had a very nutritious breakfast, steel cut oats. Then I adorned the steel cut oats with blackberries that I myself picked. It was honestly delicious. It really was. That might have something to do with the sugar. I did add a lot of sugar, but I still choose to believe that it is healthy. So Paisley's running on really good energy. Oh yeah, plus caffeine pills. But anyways, so I hope that you all are having a wonderful day. CYP is very talented. Muy talented. That's not the right word, Paisley. Jesus Christ. Anywho, so I got a lot of court today. A lot of court. But we're gonna start here and we'll go from there. Sounds like a good plan. 2 hearings in one. This is the first one. Gentleman down here appears to be pro se at the moment. Maria and her client look like they get wine together after. I know they probably don't, but don't they look like they do a little bit? I feel like they do a little bit. And then I'm really happy to see that the judge's assistant is at her desk, waiting. Yeah, you're going to need your weed for this. Yes, I heard that today was the first day of legal weed sales in Ohio. That's pretty cool. That's pretty cool indeed. I did not realize this was such a long intro. Hi, Judge. Are you wearing jeans? He's wearing jeans.
Log in.
He flew at 11:45 on.
On the matter of Kelly Lavoie versus Nicholas Alexander.
For the record, this matter is before the court for the purpose of reviewing defendant father's parenting time and any other issues. This hearing is being conducted via Zoom. Present is Attorney Maria Zagorski representing the plaintiff mother Kelly Lavoie. Ms. Lavoie is present. Defendant father Nicholas Alexander is also present. Good afternoon, everyone.
Good afternoon, Judge.
The parties have conferred with Ms. Patrick from the front of the court this afternoon, who has provided the court with the following recommendation. Defendant father will use SoberLink and all of his scheduled parenting time or whenever the children are in his care until the review date set by the court, which is October 15th at 8:30. Parenting time apparently will remain as ordered by this court back in April of 2024. Father has every Tuesday and Wednesday overnight and alternating weekends at 10:30 on Saturdays till Monday morning.
Does the judge sound a bit scratchy? He sounds a little scratchy to me. When's Owen's birthday? He said so many dates, Cole, and I just ignore him mostly. I was listening to the sound of his voice more than what he was saying. He sounds a little scratchy to me. I'm just going to say it. A little scratchy. He also strikes me as the type that would go to work sick, allegedly. No offense. That used to be a positive trait for people. It is no longer a positive trait for people. October 15th. Wonderful. Oh, October. Yeah, it just sounds scratchier. Like, I don't know. I mean, yesterday was a holiday here in my province. It was BC Day. So some people have scratchy voices this morning. I don't, but I forgot it was until like the middle of the day. I was like, why are you, to my roommate, I was like, why are you here? It's Monday. Aren't you gonna go to work? And he was like, it's a holiday, dumbass. I was like, oh, okay, yeah. And I guess I am a dumbass.
That parenting time will continue, Ms. Sikorsky, is that correct?
Yes, his Saturdays start at 12:30 though.
Okay. Further, that with respect to child support, that commencing February 1st, 2024, defendant father Nicholas Alexander will pay child support in the amount of $681 for the two minor children of the parties. Based upon 156 overnights to dad, 209 overnights to mom. Uninsured medical expenses shall be divided as follows: 49% paid by the plaintiff mother, 52% paid by the defendant father. Extracurricular activities shall be shared by the parties as follows: plaintiff mother paying 49%, defendant father paying 51%. That is the recommendation. And again, review October 15th at 8:30. Ms. Gorski, is this recommendation good with your client?
It is, Your Honor.
Has Mr. Alexander paid the $1,300 previously ordered?
He did.
All right, thank you. Mr. Alexander, do you understand the recommendation this afternoon?
Yes, Your Honor, and I do not agree with it.
Okay, what do you not agree with?
Well, first, the SoberLink, I agreed originally that I would do it on the days that I clarified with Ms. Zaborski at the times that were laid forth, and I've done that. And I agreed to do that until today's hearing. I'm asking that be reviewed and be good. I've had 0 positive tests in that time. It was discussed in the beginning that at this time, at this hearing, we would go over those findings and at that point determine whether the temporary order, I guess, was going to continue or not. So I'm asking that we do that. I also, as far as the child support goes, I guess I would need to get some clarification on a lot of things with that as well.
Okay, I'm not sure if I can answer your question regarding child support. It's all based upon your respective incomes. Did you review your income with Ms. Patrick?
I did not
Your
know.
Honor. Because when I tried to speak to Mr. Alexander, he was very rude, told me to stop talking, and he wanted to speak to the court. So I ran the guidelines, Your Honor, and I can give the court how I did it. I put mom in at 61,000. I put dad in at 74,000. Mom has, she provides daycare for the youngest child. We put that in at $185 a month, or excuse me, $224 a month. She pays the healthcare premium. She carries the minor children on insurance at $185. That is how the child support was calculated, Your Honor.
Okay. Is that a correct statement of your income, Mr. Alexander? 74,000?
That's pretty close. But as far as the
Well,
other two go, the child care and that, I guess I don't understand why I would be responsible for child care on her parenting time.
Would you
I
like
guess
me to answer that, Your Honor?
Please, Ms. Patrick.
Per the Michigan Child Support Guidelines, because mom is working and we include.
Do not be rude to the friend of the court. Mary Patrice Patrick has better relationship with this judge than you could ever wish for, sir. And you see what he's doing? He's deferring to her to answer all your questions during court. He's doing that on purpose because it seemed to bother you before to have to speak with her. And now he's making it so she's going to tell you all this shit. Because guess what? She knew this shit before and you didn't listen to her. He's literally doing this to piss you off, sir. I hope you're listening.
Included her wage in the calculation. She's entitled to childcare just as you would be entitled to childcare if you had it. Because we're using the income while working, we have to give credit for childcare.
Okay, so then therefore, if I have child care during my time, that would be calculated as well?
That's correct. By a state licensed daycare center that you're paying. We do not use family members.
Okay.
Does that answer your question about child support?
Not really, Your Honor. So what I'm asking, Your Honor, is two things. One, as far as the issue with SoberLink that, we went over back in April, again, we discussed that would continue until today's hearing on the times and days that were laid forth. And I clarified multiple times with Ms. Saborski, and I've done that. And I've done it on every single time I've been asked or ordered to do so. So I'm asking that be reviewed and can be clarified and ended today. There's also, the amount of $685 that I've paid for that I was told that, as long as there were no positive results, that I would be reimbursed. So I'm asking that we review that. And then I guess the other issue as far as child support goes, I really feel like I probably need to retain counsel to go over that. So I'm asking that be, I guess, stayed until I can do that and go over that with someone.
Is Mr. Alexander currently paying child support to Ms. Gorski? Is this just an increase?
No, he's not paying any support at all. And, no, he's not. He's not paying.
Okay. Well, the court declined to adopt this recommendation about the child support, Mr. Alexander. You can have an attorney, you can retain an attorney, have the attorney view it. And if the attorney feels that the friend of the court is way off base with a recommendation, you can file a petition to modify it. With respect
when does this take effect?
I'm sorry?
When would this take effect?
February, it's recommended that take effect to February 1st.
So
Again,
I'm essentially
not paying any support right now. The court wants you to pay some support right now. This goes back to February. Obviously, when mother petitioned the court for child support.
My proof of service is January 11th, Your Honor.
Okay, so it's probably go back to February 1st. The court's will adopt this recommendation. So you pay child support $681. There'll be arrearages, and get an attorney on board and have that attorney review it. And I'm sure Ms. Patrick will be available to review with that attorney the amount of child support and how it was arrived at. And if he feels there's basis to petition the court to modify, you can modify it, Mr. Alexander. With respect to reimbursement for the breath test, the SoberLink, Mr. Gorski, was there any provision, any prior order that provided for address a reimbursement of that expense?
If he was clean with every blow,
I'm sorry, I do see that.
Yep.
I do see that.
But if I may address that, Your Honor, the order was entered on April 1st. Mr. Alexander was supposed to provide 4 months worth. And this review was set based on 4 months from April 1st. Mr. Alexander didn't begin the process until May 8th. So first of all, we don't have 4 months of records. We only have 3 months. The other issue is that Mr. Alexander has been playing kind of fast and loose with the times that he has to blow. For example, on July 20th, instead of blowing at 10:30, he blew at 11:45. He came to court today claiming that I misinstructed him about whether he had to use it on Thursdays during his parenting time. And I may have said Tuesdays and Wednesdays on his overnights, but he has the children all day on Thursday, and he's never, well, he did provide one test on a Thursday. So I think he did know he needed to test on Thursday while he had the kids, but he usually doesn't test on Thursdays at all. He's missed times entirely. There was a Tuesday morning when he just didn't blow. So his record is less than stellar, and it hasn't been 4 months.
Has there been any positive tests?
There have not. There have not been
Okay.
any positives, but when he misses a test, it may be because he has to wait for the alcohol to get out of his system. I can provide these to the friend of the court office. We do have a hard copy of every time that he's tested with his facial recognition. He has not complied with the times or the dates as ordered.
Well, 1 hour perhaps in this course opinion would not make a difference. If he is supposed to test at 10:30, test 11:45, I don't think that the result would be affected by an hour and 15-minute delay.
Okay, and he was ordered to do 4 months. So if he wants to do another month and actually test on the Thursdays that he has the children and test on every day that he has the children at the appointed time, he would be in compliance with the order, but today he is not.
All right. All right, so we'll move up this review. We'll give him another month on SoberLink, and we'll address reimbursement when we come back, Mr. Alexander. So
Your Honor,
again, you
can we
should
just-
SoberLink on your scheduled parenting time and whenever the children are in your care till the review date, and we'll set a review date in maybe 1st of September. We'll move it
Your
up.
Honor, could I
Change
just
it,
please
yeah.
clarify?
One more month of SoberLink. Go ahead, Mr. Alexander.
I just wanted to, one more month. Okay, I just want to clarify that what we consider parenting time, because I tried to do this in the beginning and I was told Tuesdays and Wednesdays, and I've tested it all during those times, Tuesdays and Wednesdays, and Saturday starting at 2:30, and then all day Sunday during those times. So I just need to clear if I'm not doing it right. I was trying to do it right, and I was trying to do it on the days and times. Now I can't do it exactly on those times, as you said, Your Honor, an hour. Honestly, it's usually not an hour, maybe 15, 20, 30 minutes if I'm at work or doing something. I'm trying to do what I'm supposed to do, and I tried to clarify this to begin with so that there was no hiccups and there was no problems, and now here we are, and there's hiccups. So
Okay.
I want to clarify exactly when I'm supposed to be doing this.
I think it's primarily whenever you have parenting time, whenever the children are with you. So the order says on your parenting time days.
On the other hand, the judge is snippy to everybody virtually. Hi, Courtney. I know I was early today. You know me. Unpredictable as fuck.
6:30 a.m., 10:30 a.m., 2:30 p.m., 6:30 p.m., 10:30 p.m. No reason to be an hour late, Mr. Alexander. You go into if you're at work, you go into another office, or go into the restroom and then test. You do that in your privacy. There's no reason why you should be doing an hour late. So I'm not sure where the confusion lies. These are your parenting times are every Tuesday and Wednesday overnight, and alternate weekends, Saturdays at 12:30 to Monday morning. Ms. Gorsuch, you got to
Right.
clarify your understanding of when he's supposed to
No, Judge, he
adopt this
asked,
overlink?
I think the confusion came from me saying Tuesdays and Wednesdays because he has those overnights, and he took advantage of me not saying specifically Thursday, despite the fact that he has the children all day Thursday. Mr. Alexander likes to look for any loophole and take advantage of it, and that's what he did. Your order is very clear, and I don't represent him, work for him, or advocate for him. If he had any questions, he should have been asking the friend of the court or consulting with counsel. And I find it offensive that he shows up today and blames me for his lack of compliance.
What are Mr. Alexander's, what's his parenting time on Thursdays?
He has the children until my client gets off work Thursday evenings and picks them up. And he has never blown on a Thursday,
Or a Monday.
except for once. And he's never blown on a Monday morning, and he has the children on Monday mornings. So that's what I was saying about playing. He's playing it fast and loose, Judge.
Your
Okay,
Honor,
do we
I'm
need
not
to-
trying to
do we need
play
to-
any game. I'm just trying to clarify. I was not trying
Okay,
to play any games.
let's spell out every day and time, okay?
Okay,
Saturday. You test at, what time? The order's doesn't address every day, it just says parenting time days. So when he gets children at 12:30 on Saturdays, does he test, at what? 10 o'clock?
He should start at 2:30 in the afternoon.
Well, shouldn't he test before he has the children?
Well, we would love that, but he's only done it while the children are in his care. It would be nice to know
Right,
that he's
all right.
sober going into it.
All right, let's keep that then while the children are in his care. So when the children are with you Saturday through Monday, you test at on the Saturday and Sunday. Saturday at 10:30, 2:30, 6:30, and 10:30. Then Sunday, 6:30, 10:30, 2:30, 6:30, and 10:30. And then Monday morning, what time do the children leave your possession on Monday mornings?
After I get off work.
He has them all day until my client's done with work. So he should be testing all
Okay.
day long.
So you should be testing all day on
Until
Monday as well as on
5.
Thursdays, Mr. Alexander.
until what time Monday?
What time do the children leave your possession?
Well, I drop them off in the morning, but I mean, I obviously not drinking at work, so, but I'm not trying
When
to
the
play any
children in
games.
your possession, if you drop off the children at 10 o'clock, then I guess.
I drop them off at 8 and I drop them off at 8 in the morning on Mondays and 8 in the morning on Thursdays.
So to blow at 6:30 in the morning.
Okay, and then, so I just want to clarify the times then. So I'll just start on Monday. So Monday, I need to blow at 6:30 in the morning.
When the children are in your
On-
possession, correct?
Well, but
Okay.
but
And then
let's-
on Tuesday,
I'm sorry,
on
Mr.
Tuesday,
Alexander.
I pick them up at 5:30. So on Tuesday, then I would start at 6:30 and at 10:30, correct?
Judge, Mr.
And then
Alexander,
on Wed,
I'm
I'm gonna
sorry,
talk with Ms. Patrick. Ms. Patrick, can you spell out the days and the times that he'll blow, please? Let's walk through every day and we'll specify the dates on, the times on Tuesdays, Wednesdays, Thursdays, Saturdays, Sundays, and Mondays.
You know, I've heard of marriages like this where they actually spell out every blow occasion. You know, not just birthdays and Christmas or anniversary and promotions. I'm talking every Tuesday blow job. I mean, blowing, all the days, written out, contracts signed, go, go, go. But you know, if you're blowing that much, you usually don't need a contract. Tends to be that you like it.
If you can set forth that, and if you could, Ms. Patrick, we have time, and then we'll come back. And we'll set a review date for the 1st of September. We'll get another review date, so if you put that in the order.
You did.
I'm sorry.
That was for the puppy. She wanted a
Okay,
puppy.
give
And
me
she got,
September 3rd.
she gave
September
blowjobs for
4th.
puppy.
How about September 4th? 9 o'clock? How about review on September 3rd, 9 o'clock, you available?
September 3rd,
Or the 4th? We're gonna give you one more month of SoberLink.
It's a portable device, Barb. You carry it with you, and at those times, you
Sorry,
go and you
Anna,
blow
you're
into
asking me.
it. It does a facial
Ms. Gorski,
recognition.
you
and then
available on
you
the
blow
3rd or
into it.
4th of September?
I can make myself available. Yes, Judge.
Okay, so, what'd you say?
Sometimes the best blowies are without facial
How about
recognition.
9 o'clock on the Tuesday, September 3rd, day after Labor Day?
Glory hole.
Sure.
Will that work with you, Mr. Alexander?
That doesn't really work for me.
you said 9 o'clock?
Yes, 9 AM. September
Yeah,
3rd,
9:30. Yes,
the
that works.
Tuesday morning?
I'm
Yes,
sorry,
that works.
that doesn't work for my client. She has to do payroll at work. Can we do the 4th instead?
Okay. Okay, we'll go to the 10th. 9:30 on the September 10th.
That's fine.
Hey, Ms. Patrick, we can put a review September 10th at 9:30. If you can meet with Ms. Sikorsky, Mr. Alexander, specify each day that the intent of the court is that Mr. Alexander submit to the sober link during his parenting time.
Yes, Your Honor.
And the order, the last order that was entered does not specify Thursdays and Mondays, but obviously he's got the children with him sometime on Thursdays and Mondays. All right, thank you, Ms. Patrick. Mr. Alexander, we'll put you back in the breakout room with Ms. Patrick, and you can go through and we'll spell it out. But I want one more month of testing, and if there's no positive, then we can talk about reimbursement. We come back.
Okay.
And so we'll have you come back out.
Thank you.
No positives. That will work well for him.
Josh has the,
It'll be very hard to argue with. We're going to continue on here, folks. We have another hearing coming up. Judge is already cranky, and this hearing goes a little bit off the rails, I will say. Once again, we have a pro se litigant. Or
because it's a school.
who the fuck is
Right.
talking?
Yeah, no, we need to do that.
Who's talking over me? Ladies, have some respect for me, please. God, thank you. Anyways, so we are gonna watch this hearing. It appears that mom is pro se or her lawyer is not available. And then the discussion is about school because school starts soon, guys. A lot of people need to be look at her blanket. It must be cold in there. A lot of people need oh, I guess you register for school early on. She has a tattoo sleeve? Really? That's cool. They're mad at me because I muted them. I'm sorry, ladies. I have a show to do. I have to talk sometimes. Okay?
Wait, how did Kismer get 1 week?
See how scratchy he sounds?
Father on July 25, got
That
no,
vocal
he just mailed
fry.
it out on July 25. That's got such a quick hearing date.
Here we go. Oh, she's sideways. Girl. Hi, girl. What's up?
Okay.
Calling matter of Kristen Westfall versus Douglas Platt.
For the record, this matter is before the court and the defendant files a motion to enroll the minor child in school. This hearing is being conducted via Zoom. President's attorney Jason Kazmarek, representing the defendant petitioner Douglas Klatt. Mr. Klatt appears to be present. And it looks like we have someone upside down here or sideways. You are Kristen Westfall, is that correct? There you go. That's much easier to see you.
Sorry.
Right. All right, the court's been informed, Ms. Westfall, that you want to retain an attorney. Is that correct?
Yes.
Obviously, the timing is very critical. We need to make a decision on the enrollment of this child in school. Mr. Klatt is requesting Monroe Public Schools, and you're opposed to that?
I am aware that we're in like a time sensitive nature on this. I was not aware that there was an issue with schooling up until I got the papers in the mail. I have verbal consent from Mr. Collette to homeschool this year, so I don't even know how we got here.
Mr. Kazmarek, has the minor child been enrolled in Monroe Public Schools?
He has, and again, I know that mom was kind of upset, I think, about a IEP that the school did, saying that he no longer needed the program.
The court's aware, the court's read all the pleadings, the court's all aware of
Understand.
all that.
So,
And I'm just
but
asking
but
if he's been
the child
enrolled.
the child has been enrolled at Manor
Okay.
previously, but my client is fine with some kind of faith-based program as well, like St. Mary's or St. John's, and potentially willing to fund most of that as well. So
He just wants them in person in school as opposed to homeschooled, is that correct?
yes,
Right, and Ms. Westfall, you're opposed to DJ going in person to school?
Correct, and DJ does not want to be in school either, and he has voiced these concerns to Mr. Collette as well. I have text messages just so far as the beginning of July where Mr. Collette has agreed for him to be homeschooled and to purchase his books this year, so I don't know where we're at with public school and how we got here when just a few weeks ago he told me he purchased books and he was fine with DJ being homeschooled.
I think my client disagrees with that. My client's always willing to support his child. I mean, whatever he needs. I don't think he's ever consented to the child being in homeschool. That's the biggest problem. I know that mom kind of did that with the understanding that a misconception of how he's going to be taught. But I know this homeschooling program is supposed to start on the 19th. There's no teachers. Miss Westfall is the teacher. Her boyfriend is the principal. And if this was a true, more online school, there's online teachers or something, my client could be more open to it. I know that he's concerned about the interaction with other students and teachers and having programs available for this child. And he's not getting that. And that's what he's most concerned about. Whether, again, he's willing to foot the bill for most of this stuff. It's so he's not getting updates for his education. He wants somebody accountable, giving attendance records.
Is that hyperbole? Her boyfriend is the principal? I'm being serious. Like, is that him? I don't even know. I'm being serious. Like, are they just because he lives there? Or is he literally associated with the school? Oh my. Now I have a lot more questions.
And grades. Miss Westfall does all the grading, and she isn't. Again, there's no information to Mr. Cladd about how this child's even doing. It's just
That's false.
He wants the
All
child.
right, it sounds like Mr. Cladd and Miss Westfall need to communicate and talk about what's best for their child. Have they talked about this?
Mr. Clatt refuses to communicate with me.
Oh, he would love to.
I have sent numerous
All
text
right, so
messages.
hold on. Right, you're getting you need to get an attorney on board real quick, Miss Westfall. The child's been enrolled in Manor schools, and that will start the first week of September. Is that correct,
Well,
Mr. Kazmarek?
Well, he had been previously enrolled in Manor, so unenrolled him and did a homeschooling program, which is set to start the 19th.
He can be enrolled. He can be enrolled in Manor School. That doesn't start till the first week of September. Is that correct?
Yes.
We have already agreed for him to be homeschooled this year, and I have already spent close to $600 for him to be homeschooled this year.
I have to reimburse you for
Clatt-
that. If in fact, Ms. Westfall, get some receipts together. If in fact you purchase those supplies based upon representation agreement of Mr. Cladd to homeschool and you incurred that, no reason why you can't tutor your child in addition to the regular schooling. But there is some value in-person school, socialization with other students, extracurriculars. So the court will allow him to be enrolled in Manor Public Schools and start there the first week of September. And if you want to, can you get an attorney here before then?
My attorney is asking to adjourn this for 2 to 3 weeks so he can
But he's
file.
not here. If I set a date, he's gonna say, well, that date's not agree with me. So I can't guess about a date, Ms. Westfall. So here's what I'm gonna do. The court's gonna, is Mr. Cladd opposed to reimbursing Ms. Westfall $600 for the education materials?
No, not at all.
All right, so provide a receipt for the education materials, Ms. Westfall to Mr. Cladd, and he's ordered to reimburse you for the education materials that you've incurred so far. The court will also order and allow this child, because we're on the eve of, we're less than a month before school begins. The child can be enrolled in Monroe Public Schools, Manor Schools. If in fact you disagree with this strongly, have an attorney file a motion to ask the court to reconsider, Ms. Westfall. There's no reason why you can't do both. Can't you tutor him and help along and he'll be a super student?
It's not. I'm sorry. Please give me a second to collect myself. It's not tutoring him. I have a whole school curriculum through a accredited homeschool facility with actual subjects laid out, with actual lesson plans for each individual day. I follow a whole lesson plan for each day for each subject. It's not just me tutoring him or making up my own curriculum. It is a whole curriculum based off of accredited college out of Florida, where each subject is laid out day by day with homeschooled lesson plans that he would follow just like as if he was in public schools. The only difference is he's not being bullied. He's not being made fun of because of his autism. He's not struggling to make friends and be bullied by said friends because he acts differently or has to learn in a certain manner. I don't understand
Understood,
how
but
he
you're
can
not a
agree.
certified teacher. correct?
I'm sorry.
Not a certified teacher.
I'm not a certified teacher, but I have taken plenty of online courses on how to deal with my autistic son.
Okay. And Mr. Kazmarek, Mr. Klatt disputes this finding of autism. Is that correct?
I don't, it just, I've never been involved in any of this diagnosis of my son being on the spectrum of autism. And he was at the Arborwood School for Autistic Children. They put him into Manor because he no longer needed the teaching that it was taught in the beginning about the autism. Had he had autism, I'm assuming they would have kept him there instead of sending him to public school where he succeeded. And I have the records, the documentation from the school board. There was no reports of bullying. He succeeded the level to need an IEP teacher, and his grades were fine. He was being successful the whole year that he was in Manor. He did great, and he was able to function, get along with the children. And there was reports of bullying and stuff. I went to the school board. There was no files of any bullying. There was no reports of struggling with grades. He was doing fine with his report cards, and they took the IEP because he was above the level to require it, sir.
Right. Well, Mr. Klatt, you should be involved and on top of all those evaluations. You say you weren't really involved in them. You should be. The two of you are parents. You should know what's best for DJ, and you're making a total stranger decide what's best for your child and raise your child, which is very unfortunate. You need to get on board during the pandemic. Communicate with Mom and Mr. Westfall too. We need to talk. You should both be involved in a mediation session so you can work through this together.
He refuses to show up.
There'll be future issues. If you cannot agree upon school, this is the beginning of many issues. So at this point in time, Mr. Klatt, you order to reimburse Ms. Westfall any material costs that she has incurred, and the court will permit the child to be enrolled in Monroe Public Schools, Manor School. Ms. Westfall, if you disagree with it, you want to have an attorney file a motion. And again, there's no harm in DJ starting a week or two of school if we need to change horses. But the two of you should talk, and maybe Mr. Kazmarek and Mr. Vidal files and parents, maybe you can schedule a mediation between with the front of the court. I'm sure the front of the court will be willing to mediate with the parents to talk through this together.
This is so unfair to DJ to be forced into school for a few weeks to be pulled out when Mr. Klatt has already, I have text messages from this year that he could be homeschooled. So why are we even going through this process?
I can't answer that question, Ms. Westfall. Mr. Klatt he owes you that explanation, but in the meantime, the court, he's going to reimburse you 100% of whatever you've incurred for educational materials. So, Mr. Klatt, you need to talk with the mother of your child. Otherwise, you're going to have problems with DJ. I'm telling you. So if you can prepare an order to that effect, Mr. Walker, this does not prejudice Ms. Westfall. She can still have an attorney file a motion to reconsider the issue. But out of times of the essence, we can't wait. We need to make some decisions. And Mr. Klatt, if he's being bullied, you should be cognizant of that. Maybe it's best that he be homeschooled if he's being bullied and he's got autism. You should contact the people who did some of those reports.
I did.
The IEP says he has really good social skills and they get along well with other students. That's why he's confused with that assessment from Mom.
That's because Mr. Klatt doesn't reach out to me. He does his own investigation and then just goes from there. He's yet to reach out to me about anything.
I'm the one that asked you about the bullying and the homeschooling.
Okay. All right, Mr. Walker, if you can prepare an order in accordance with the court's instructions, and that will conclude this hearing. Ms. Westfall, you get contact Mr. Vidal and have him file a petition with the court. All right. That will conclude this matter.
Wow. It's interesting. She didn't really have a kid, or sorry, an attorney there, but she's talked like she has an attorney. If your attorney's not showing up, it sounds like you haven't paid your attorney. Have we watched this? Yes, obviously, because of that. Hold on then. I was looking for a different file. This is the one.
This is in the District Court of Butler County, Kansas, case entitled Charity Hahn Petitioner versus Jordan Phillips Respondent, case number 2017 DM 581. Would counsel announce appearances for the record, please?
May it please the court, Your Honor, Matt Olson appears on behalf of the petitioner Charity Hahn, who is also appearing via Zoom on her iPhone here this afternoon.
Your Honor, if it pleases the court, the respondent, Jordan Phillips, appears by his attorney, Tony Potter, via Zoom. Jordan has practice this afternoon. He was going to try and get away, but he indicated to me that he was fine with us going forward if he wasn't able to get away.
In case you guys don't know, Jordan is an NFL player, apparently, and is at practice. Also, I don't know if I'm allowed to talk about that yet. Anyways, regardless.
Very well. Court will note that the matter came before the court for hearing and oral arguments on July 12 of 2024. There were arguments made regarding the child support reduction issue. The court took the ruling under advisement and stated that it would announce its ruling today by Zoom. Counsel, before I get into the remainder of my ruling today, I want to try to get some assistance from the attorneys regarding one of the building blocks in the child support worksheet, which I can't seem to reconcile with one another. Looking at the two worksheets side by side, I will note, Mr. Olson, that you gave Jordan a credit in the amount of $644 for insurance or work-related child care costs, yet Mr. Potter, in the representation of his client, had zero, I think, in the same slot. Can you explain?
I'm
Whether
looking
one of you
now.
might be able to? Tony, does he indeed pay out of pocket for insurance for MVP?
My understanding is that he doesn't, Your Honor. The health insurance that's provided is provided for dependents without cost to him. I can double check that, but that's the information that I have. And I think that that's how we've included it in the domestic.
Tell me which other job that you go to practice for covers your children for health insurance at no cost. He's an NFL player, y'all.
Relations affidavit that we filed with the court.
Yeah, and
Well,
I
it would have the net effect of actually increasing his gross child support amount potentially. So,
and I don't know why that's in there, Your Honor. I apologize. I went back and referenced the worksheet that was done, or I believe that was done before. And I don't think there's a history of that credit being included. So I apologize. I don't specifically know off the top of my head. It very well may be a mistake. And obviously, if Mr. Potter's saying or indicating his client's not covering the cost, then that very well is a mistake.
all right. That will be relevant to the ultimate computation of child support, which will eventually ensue. All right. Thank you, counsel. I appreciate that. The court will announce its ruling at this time. This matter comes before the court on a motion by the father, Jordan Phillips, to reduce his court-ordered child support obligation. The issue before the court is establishment of an appropriate amount of child support in light of the father's substantial salary reduction of approximately 65%. This court has considered the pleadings filed in relation to this matter, the exhibit notebooks submitted, and the oral arguments made by the attorneys at the July 12 hearing. To summarize, the movement, Mr. Phillips, has submitted a child support worksheet suggesting a new child support amount of $1,073 per month. The mother has submitted a child support worksheet suggesting that child support should be currently set at $5,102 per month. This court finds that the mother's child support worksheet appropriately sets forth the current income of the parties, which contemplates the application of the extended income formula. The mother's child support worksheet also properly reflects an interstate pay differential adjustment, the accurate child age category, appropriate application of a multi-family adjustment, and the court further adopts an appropriate credit of zero for insurance or work-related child care costs, which will be an adjustment to be made to that worksheet. This court has considered, but specifically declines to grant an adjustment for income tax considerations, as the parties previously agreed to alternate the claiming of MVP on their annual tax returns, an agreement with which this court will not interfere. Further, the court declines to grant the father a parenting time adjustment, as his time with the child, while substantial, does not merit such adjustment at this time. The court also finds that the father has chosen his profession as an NFL player and further chosen to live in the state that the team city that he plays for is located. Based on these circumstances, this court in its discretion declines to adjust the father's child support obligation for any long-distance visitation costs his chosen profession necessarily causes. In essence, then, this court adopts in substantial part the child support worksheet proposed by the mother and her attorney. However, this court also considers whether an overall financial circumstances adjustment should be made regarding one extraordinary expense that Jordan Phillips has undertaken, namely the obvious value of his financial contribution of the Andover house that the mother and child of this relationship live in.
Okay, he bought the whole house for her. Okay, this is fucking good. I'm gonna have to make this into a video with some shots of him playing football interspersed. Yeah, I don't think so either. I don't think so. If we were to look on the screen right now and guess which lady was the NFL wife, would we think it was me or her? That's really just trying to make myself feel better. Also, did you hear the way that the judge said declined? It sounded very much like how they say it in football. Declined.
As the father's Exhibit J shows, the contributions Phillips has made to home insurance, home improvement, payoff of the home, property taxes, refrigerator purchase, and window replacement amounts to a total in excess of $900,000.
In Kansas? $900,000 in Kansas is a lot of money. Oh shit. Plus $5,000 a month? Wow. Wow.
This house, based on a credible proffer by Jordan's attorney, has a current rental value of $4,727 per month. Upon review of the file, however, it is apparent that Mr. Phillips' agreement to provide the house to the mother was at least in part to settle financial matters with her, not solely to provide support to his son MVP. Therefore, this court determines that only one half of the monthly rental value of the Andover house, $2,363, should be considered by this court to be a contribution in direct support of his child. In exercise of the court's discretion, an appropriate overall financial circumstances adjustment must be made to achieve a just and equitable result here. The providing of a home for a child is normally the responsibility of the primary residential parent and child support recipient, with a degree of financial subsidy and contribution from the child support payor. Here, though, the father provides what is in essence a rent-free, mortgage-free house for the mother and child to live in, which benefits and is in the best interest of the child each and every month that the child lives there. Therefore, this court orders that an overall financial circumstances adjustment to Mr. Phillips' child support obligation in the amount of $2,363 per month shall be reflected by the amended child support worksheet to be prepared in this case. The court also will direct that the apparently mistaken credit for insurance or work-related child care paid be removed from the computation, which would create what it would appear to be a proportionate child support obligation for Mr. Phillips in the gross amount of $5,721. And then the deduction for the $2,363 would need to be made from there.
Huge down payment, Mike.
So with those
She doesn't own the
announcements,
house. Remember something. She doesn't own that house. It sounds like they are living in that house, but rent-free and mortgage-free, but he's covering all those costs, and I imagine it's in his name. So she should save her money that she's getting paid.
no other adjustments are specifically ordered by this court to the basic building block numbers suggested by Mr. Olson's child support worksheet, except that the child support enforcement fee should be adjusted to a 3% figure commensurate with the current order of Butler County. Mr. Potter is directed to draft an appropriate modification order with a proper child support worksheet attached, as adjusted by the court's rulings today. The effective date of the adjustment is ordered to be July 1, 2024, with the court determining in its discretion that to be the most appropriate retroactive effective date. It may be easier, counsel, as often as is done in domestic cases, that perhaps the person whose child support worksheet was substantially adopted, which in this case was Mr. Olson's, perhaps make the adjustments to the worksheet itself and get it over to Mr. Potter.
Can do, Your Honor, for sure.
Court has long taken the position that it's the court's prerogative to determine all of the building block numbers to go into a worksheet and then let the programs and let the computation take place from there. But I will ask Mr. Olson, do you need any further clarification from the court regarding putting together the adjusted child support worksheet?
No, I think the court is very, very thorough, and that should be more than sufficient for what we will need.
I think it's going to result in a net reduction. I'm just looking at the numbers here to about $3,400 a month. But obviously, however it comes out. All right, Mr. Potter, do you need any further clarification from the court?
Yes, just a few items, please, Judge. I would ask that you just reserve the issue of the health insurance. I do think that it's zero, but I'd just like to double check since Jordan isn't present today. And if that number changes, I can certainly contact Mr. Olson and provide him with that verification. And I'm sure we can include that in the child support worksheet. The second
That would be appropriate.
Excuse me, I'm sorry. The second issue would be that with the child support being retroactive to July 1, I would ask that the court give Jordan credit for any child support that he's paid over and above that amount since the July 1 date.
Has he paid August support?
I believe the July support has been paid, and it looks like the August support has been paid as well.
He is entitled to such credit. Is my understanding. He had no arrearages.
Correct.
Yes. That would be appropriate.
So he's paid ahead. Is that the first time you've ever heard? It's the first time I've ever heard. He's overpaid his child support by $2,500 a month or something. Wow. Might just draft this guy in my I default to hockey pool, my football pool, just because of that. Actually, that might be a really good way to check on which players I'm going to pick based upon their child support status.
However, I would just ask for your side of the case, Mr. Potter, to consider the economic impacts of an offset being done all at once and perhaps spread it out over several months on the child support overage recovery. And I hope you're following the court's suggestion here.
I am, Your Honor, and if Mr. Olson is better at IM than math, I'm sure that we can figure that out. So,
Okay.
Well, I don't know about that, but I'm sure we can figure it out, Your Honor.
I have every confidence in the world in counsel's ability to do the proper mathematics here. All right. Anything further we need to address from either one of the attorneys in the case?
Not from petitioner, Your Honor.
No, Your Honor.
Very
Is
well.
that really
Thank
it?
you all for your
Thank you,
attendance
Judge.
today and participation
You're
in this
welcome.
proceeding. If there is nothing further, this matter will currently be in recess. Mandy, you may end the meeting for all at this time. Have a good day.
Mandy.
So you
Thank
too.
you, Your Honor. Thanks.
Mandy. Thanksy. Wow, 5K a month, taking into consideration the 900K house that he's putting up for them. But we've done a little research. It looks like he already has 2 other kids with his current wife, and they live in New York. He plays for the Giants. Is that who it is? Interesting case. Thank you, Lucy. Got a lot out of Kansas today. In fact, a beaver, I don't even know how to say it. M-worder, unaliver, a beaver unaliver in Kansas that we're going to probably watch tomorrow. I just have to put both parts of the case together. This guy is shady in more than one way, okay? He's not just killing unaliving beavers. He is messaging prosecutors. He is pissing off the judge. So we have that to look forward to tomorrow. Plus, okay, phone, can you just calm down? Okay. What was I thinking? I can't remember. Anyways, yeah, Judge Ricky has some great cases. He is not taking any crap. I do like that about him. I really appreciate that. Anyways, but and it's 4:20 in just about 1 minute. You guys know what that means. It's time for me to take my leave and roll some leaves. That's an NFL player calling right now. Don't I wish? I mean, maybe. I don't know. I have a type. It is sort of a big guy type. So maybe that would work. Anyways, I hope that you have a wonderful evening. Remember that I love you. I am proud of you. And I will see you in the next video. Bye.